Welcome. Thank you for joining us today for our webinar on the new administration's impact on nonprofits, presented by my partner, Diz Locaria. My name is Janice Ryan, and I am co-chair of Venable's nonprofit organizations practice with George Constantine. Today's presentation is part of Venable's monthly series of webinars on legal topics of interest to the nonprofit community. I will introduce Diz momentarily and hand things over to him to get started. But before I do that, I wanted to share that next month's webinar will be on managing risk for nonprofit meetings and events. It is scheduled for April 22nd. Please look out for invitations for that session coming out soon, and we hope you can join us. Today, you are going to hear from our government contracts and grants partner, Diz Locaria. Diz has been very busy this year. He assists government contractors and grant recipients in all aspects of doing business with the federal government. He helps nonprofits, in particular, qualify to become federal contractors or grantees, comply with various federal procurement and grant requirements, and he represents clients in suspension and debarment matters, audits, investigations, including but not limited to the False Claims Act. He is very well suited to present to you all today. I'm sure you will have lots of questions for him, and I hope you enjoy the session. Thank you so much. Diz?
Thanks, Janice, and thank you everybody for dialing in today or Zooming in. As Janice mentioned, it's been a busy couple months this year. So the focus of today is to talk about a number of executive actions that have taken place, obviously, since the new administration was sworn in on January 20, and how that is impacting nonprofits. I can say that the impact has been significant, and that's why things have been so busy. So I'm going to just jump right into kind of the meat of this stuff, and hopefully we'll have some time. I'm trying to keep 15, 20 minutes available for questions at the end, or even throughout. Janice may pepper me with some questions that you all might have, and please use the question feature there in the Zoom so we can make this more useful and real, for helpful to you, but real to everybody else is there, hearing and seeing what others are experiencing in the industry. And I'll try to add anecdotes as I go about what I'm hearing and seeing. Thankful to our nonprofit practice at Venable. I've had the opportunity through Janice, George, and others to work with literally dozens of nonprofits for several years now, but in the last couple months on these very issues. And so I'll share anecdotes as we go. So the first action that I want to talk about, and there's many actions, and we're only going to be able to touch on a few today, but the first one came on January 20, as many of them did, some of them later, but we'll get into all that. And it was the executive order on reevaluating and realigning U.S. foreign aid. And that was important because what happened was the administration put in what they called a 90-day pause, and we're in the midst of that pause still, by suspending literally thousands of awards to nonprofits, both contracts and grants, issued primarily by the State Department and USAID, but there are other agencies that have some foreign aid aspects. And, putting in this just sweeping stop work, regardless, candidly, of whether or not, there was actually a basis in an agreement to stop work. Many awards, particularly grants, don't have stop work provisions. And so it created just a tremendous amount of immediate confusion. It also paused payments, and some contractors and grant recipients had, invoices already submitted that just have, were paused as well. And in many cases, many of those remain outstanding today, now almost 2 months later. There's obviously been a lot of other upheaval, particularly within the USAID department, where thousands of workers have been dismissed and then brought back and then dismissed again, and now they're officially dismissed. And so that agency is effectively on life support with just a skeleton crew managing things. There's been very little in terms of guidance as to what the government is doing in this 90-day pause. Pretty much the guiding light has been three principles about foreign aid under the new administration, and what is probably going to be an assumption of USAID back into the State Department. As some may know, USAID was originally created by President Kennedy back in the 60s to separate political policy housed within the State Department and humanitarian assistance, to give some separation between those so that humanitarian assistance wasn't solely based on policy and politics. But the administration is going to bring it in with three ideas of, does it make America safer, stronger, and more prosperous? Those are the three kind of guiding principles of foreign policy under this administration. So with that in mind, there's been a lot of consternation about whether programs will continue. And because of that, there's been a lot of litigation over the shuttering of USAID, the pause, the failure to pay. And there's been a number of court orders in that regard. But those court orders, they haven't stopped the fact that many contracts and grants were suspended or stopped. Most of the grantees and contractors are still awaiting payment. Some have received some payments, but not all their payments. Many contracts and grants have been terminated. And then most recently, last week, foreign aid recipients received this questionnaire. And that questionnaire started out as 45 questions, and then I saw it reduced to as little as 13. And essentially, my understanding of that questionnaire was that agencies were using the information from that questionnaire to determine whether to justify whether a program should be permanently terminated or turned back on. And so last week was a exercise in speed of answering some very tough questions and questionable questions on whether or not it's even appropriate for the government to ask that. Some of them implied that free speech might be at issue. So it's been a tumultuous month and a half or so. There is litigation in place that is supposed to have stopped some of these actions. But there's been a lot of debate between the administration and the plaintiffs about what those orders, so those either preliminary injunctions or temporary restraining orders, of what they have meant and how broad they are in terms of, does it only apply to the plaintiffs? Does it apply only to the defendants? Or does it apply to all agencies? And then the terms of the orders. The government argued that, look, we always have a right to terminate, and that is true for contracts, but not necessarily the case for grants. Most grants don't have termination for convenience provisions. And so, the question was whether or not the government retained those rights to terminate. And it largely did. It was just the sweeping decision where there was no particular analysis of whether a certain program was necessary or not for the government. That was really at issue. Now we're looking at a lot of unwinding of these things. Grant recipients and contractors are trying to seek payment for suspension periods, termination settlement proposals, those things. So there's a lot of things happening in this space. A couple unfortunate takeaways is, no matter what happens ultimately with these lawsuits, is that I think the U.S. foreign aid industry is going to contract in probably significant ways. There are a lot of questions about foreign aid being directed by Congress and the Impoundment Act, and that is still to be kind of played out in the courts. But at the end of the day, Republican-controlled Congress, Republican administration, and foreign aid is probably an easy target to limit government spend. And so we're going to see some contraction there regardless. So that's kind of that first executive order that really has hit the nonprofit industry, particularly in the foreign aid, very hard. And there's a lot of things that organizations can do to protect themselves and exercise their rights. But at the end of the day, it may be difficult to retain the business long term. The next executive order that I want to talk about is probably one that's garnered as much attention as any of them, which is one that was actually executed on January 21, and this is ending illegal discrimination and restoring merit-based opportunities. So this is the DEI executive order, okay? And this one, was a plan to deter DEI programs in the private sector, primarily contractors and grant recipients. The government has a lot of control over contractors and grant recipients because they spend government money, and so they can attach a lot of strings to that. But those strings aren't limitless, and we'll talk a little bit about that. So the order essentially prevents contractors and grantees from considering race, color, sex, sexual preference, religion, and national origin in ways that violate the nation's civil rights laws. Okay, so what does that mean? Well, interestingly enough, on January 19, I would say that the anti-discrimination laws were exactly the same as they were on January 21. They have not changed, and they have not changed today. Today is, March 13, and the anti-discrimination laws are exactly the same as they were on January 19. So what exactly, is different here? Well, what's different is this next bullet here, where it talks about the agencies, directing the agencies to require affirmative certification that organizations do not operate any programs promoting DEI that violate any applicable anti-discrimination laws. Okay, so what does that mean exactly? Well, it's a little difficult to tell you what that means because terms like promoting and even DEI, other than meaning diversity, equity, and inclusion, we don't know what that means. None of that was defined in the executive order. But let me just touch on the next bullet. It also provides that contractors or grant recipients who continue to engage in this prohibited activity, quote unquote, illegal DEI, will be subject to liability under what's called the False Claims Act. And they're able to do that because of that certification. So that is a new requirement. Contracts and grants generally require people to comply with the law, including anti-discrimination laws. But now you're signing an affirmative certification, and I'll say that it's broader than anti-discrimination law because it talks about promoting DEI. Now it says that violate applicable federal anti-discrimination laws, but is there daylight between that? And that's what's not clear. What's very clear is that the administration is looking for whistleblowers, and it's looking for folks to investigate and potentially bring false claims actions against. And so what we're seeing is that the government, or what we're reading through all this, is that the government wants to create new federal anti-discrimination laws through the courts, through the False Claims Act. There is a body of anti-discrimination laws, Civil Rights Act, Section 1981, various laws that have been on the books for some time. And then most recently, the Supreme Court decided the Harvard admissions case in the summer of 2023 that limited affirmative action at higher education. But most organizations have kind of navigated themselves to be in compliance with all that. But what this is saying is that maybe there's something else about DEI that is quote unquote illegal. And we're going to get you to certify contractors and grantees so we can come after you under False Claims Act. So that has obviously created a lot of concern in the nonprofit community because nobody wants to be investigated and accused of violating the False Claims Act. There's a lot of repercussions that come with that. And certainly nobody wants to be the test case for the administration. So what that has caused is kind of a swing of folks moving to the right in terms of their DEI programs. So that's something that we need to, keep an eye on, and I'll talk a little bit more about what this means to the private sector in a couple slides. One thing I do want to note is that there is this safe harbor concept that was in the executive order talking about compliance with the regulatory scheme. But I want to be careful because it's the safe harbor, the 90-day safe harbor to stay in compliance with the regulatory scheme is often much more narrow than what many organizations are doing. In other words, affirmative action plan, that's part of the regulatory scheme. being an EEO employer, equal opportunity employer, part of the regulatory scheme. But things beyond that are not required by the regulation. And so one would, it's very possible that those are not subject to this kind of 90-day safe harbor. So want to caution folks about that. So the third executive order I want to talk about deals with the gender identity, defending women from gender ideology, extremism, and restoring biological truth to the federal government. So this executive order looked to eliminate gender ideology from forms from government forms like passports and whatnot, communications, and other messaging. For example, I know some agencies communicated that if you, nonprofit, contractor, grant recipient, are communicating with us via our email, because some folks are co-located, so they might have a government email, not allowed to use pronouns. Other agencies even went as far as saying, if you're going to communicate to us, meaning from your private domain email address to us, you should not include pronouns. So things like that have been discussed and put out there. Essentially, it's an end of federal funding of gender ideology issues. And the government is going around and reviewing all the grant conditions and preferences to ensure that they're not promoting ideology. And similar to the last EO, I didn't focus on it, which rescinded a bunch of executive orders that related to DEI and affirmative action and those types of things. This one is also rescinding a number of executive orders that relate to kind of gender ideology issues. Okay, the fourth thing I want to touch on is another action by the government, but not through an executive order. This next one also caused an extreme concern among nonprofits on the domestic side. And this was not through executive order, but rather through OMB, the Office of Management and Budget. On January 27, they issued a memo that caused for a pause again on all activities related to the obligation or disbursement of federal financial assistance to allow for a complete and comprehensive analysis of all the federal financial assistance programs to identify programs, projects, activities, et cetera, on whether or not they comply with the president's executive orders. Now, there were a couple limited exceptions, mostly programs that had direct benefits to individuals, student loans. There was some publication about Meals on Wheels, however, they were paused. But at the end of the day, this impacted nonprofits domestically across the board for the most part. So the foreign aid freeze impacted kind of one segment of the nonprofit. This impacted a whole different segment because it really put a strain on folks by pausing all payments. Now, some organizations work on advances, some work on reimbursement. Either way, a pause, when you have a very kind of systematic process, that pause can create a lot of upheaval, and it did. And it was challenged very quickly in district court up in Rhode Island was the most notable case. And the memo was rescinded, but the court action continued because part of the TRO that was issued by the judge said, look, anything similar to this is also prohibited. Again, the basis for it was that this was a broad swath of action that wasn't focused or particularized about any program, and that this broad kind of government-wide action was detrimental and unnecessary. And so that TRO was put in place. A couple weeks later, a preliminary injunction was put in place. They're having full briefings, but in the meantime, that case has been appealed by the administration up to the First Circuit. And so, we're kind of waiting to see whether or not this is something that the government will be permitted to do in the future or not. But fortunately, I think this one had a lot of public upheaval. And so that memo was rescinded and funding was restored. But I'll say, in talking to a lot of my clients, that couple days with that memo in place really bogged down the payment system. and it took weeks for payments to start coming again on a regular basis. And we're still seeing some residual effects of that. And that's a very, so that was another action that was pretty detrimental to the nonprofit community. And then one more I want to talk about today, and I'm going to get into some of the challenges that we're seeing. But this one, again, probably focused on a segment of the nonprofit community. This related to NIH, National Institute of Health, issued on a Friday afternoon. It issued guidance that said for any new grant issued and for all existing grants to higher ed, retroactive to the date of issuance of the supplemental guidance, they're going to input a 15% indirect cost rate, and they were making that effective on the Monday after that Friday. So it was very confusing in terms of how it was written, because it talked about new grants, existing grants, retroactivity. It wasn't clear if the retroactivity only applied to institutes of higher ed, whether new grants applied to everybody that received grants from NIH. There was a lot of confusion about the scope of this notice, but the bottom line was that it deviated from what is a well-developed process for how organizations negotiate indirect cost rates with the government. There is a very elaborate and often cumbersome and time-consuming process to get what's called a NICRA, a negotiated indirect cost rate agreement. But organizations have invested a lot of time, money, and resources into developing these NICRAs so they can receive a higher amount of the actual cost it takes to do research for NIH. And if you just do a blanket cut to all of that with not a single business day notice for at least for higher ed, you are drastically impacting research for NIH. And so, not surprising, lawsuits were filed, an injunction was issued, or a TRO first, to prevent that cap from going into effect. Since then, a permanent injunction has been issued. And right now, that's in place. We're waiting to see. The administration has not issued any notice of its intention to appeal that. So we'll see if they decide to appeal that. But that one looks like it's kind of been put to the side. What I would say is, while you may not be a nonprofit that gets funding from NIH, it was significant for a couple reasons to every nonprofit. The first is that, again, it's the government kind of blanketly cutting costs without any consideration. That's problematic. But more so, it was completely rewriting the uniform guidance on how indirect rates are supposed to be calculated. And if this had prevailed, you can bet your bottom dollar that it probably would have pervaded across the government. So the fact that this stopped on a dime and didn't get any further is a pretty significant development for all of us. Okay, let's see. So in terms of, I've talked about 5 different executive actions. So let's talk a little bit about challenges to them. And I mentioned a couple of them already, but let's focus on the DEI one, because that's one that is probably still the most kind of confusing, at least in my mind. So the DEI executive order was put in place on January 21. On February 14, the city of Baltimore and some higher ed education filed a lawsuit in the District Court of Maryland. This is kind of the seminal case of the DEI. There's several there. I think there's about 4 or 5 right now, but this is kind of the seminal case. And it really challenged the executive order, I'll say, on two notable grounds. Number one, there's an obvious free speech issue here, right? That you're not permitted to talk about, promote, do whatever as it relates to diversity, equity, inclusion, whatever that means. But that does seem like an impingement on, or an abridgment of free speech. So challenge on that point. But the other part, as I mentioned, a lot of the terms were not defined in that executive order. And so regardless of whether or not it infringes on free speech, I don't know what it means. It talks about illegal DEI. Well, what is illegal DEI? How is this different than what's already on the book? Because it seems to imply that there's something more than what's already on the book. the way our legal system is structured is that folks are provided with notice and opportunity to conform your conduct to comply with the law. We don't have any notice because we don't understand what is being curtailed. What is it that is illegal? Yes, I know what DEI means and I know what DEIA stands for, but I don't know what promoting that is and how that is somehow more offensive or illegal as it relates to anti-discrimination. So the vagueness, the due process was a significant issue. And on February 21, the court did issue a preliminary injunction that enjoined that provision, that enjoined the DEI as it relates to two important provisions. Number one, it enjoined the certification provision, which was that certification that you don't promote DEI activities. Now, interestingly, I didn't mention this before, but part of that foreign aid freeze, again, nonprofits in the foreign aid sphere kind of have been the guinea pig for many activities of the administration already. Not only did they get frozen pretty much on day one, but they also have been pushed to sign certifications for DEI compliance pretty much right out of the gate. And so en masse, State Department and USAID grant recipients and contractors were asked to sign certifications on the DEI executive order. We haven't seen that en masse in the domestic side of things. It's popped up here and there, but not a kind of blanket requirement. And the FAR and the uniform guidance have not yet been updated to include any of this language. And so we don't even have really a singular certification provision that we're working with. Some of those certification provisions talked about only using government funds, that you can't use, that you're certifying that you're not using government funds for DEI, illegal DEI activities. Okay, I get that. The government can limit how you use its money. That's understandable. But some of them were much broader that did appear to impinge on free speech by saying you can't use any money to do DEI. You can't do DEI at all. And that seems, as long as it's not violating other laws like the anti-discrimination laws, why can't we? So those certifications we haven't seen, and those have been enjoined. And so we shouldn't be seeing any more of those, at least for the time being. The other part is the threat of enforcement. I had mentioned whistleblowers and things like that, but Section 4 of that executive order included requirements that agencies actually affirmatively report 9 either organizations or industries that the Department of Justice's Civil Rights Division should investigate. And so that provision has also been enjoined, which is significant. Now, not surprisingly, the administration has appealed this decision to the Fourth Circuit. The Fourth Circuit has briefings on it planned which go to the end of April. So we're probably looking at a decision maybe in May. We'd also anticipate that to go to the Supreme Court, whatever that decision is, which would then put that probably on the calendar for the court in the fall, which would put a decision for that probably around June of next year. So this is going to be around for at least a year before we even know whether or not this first crack at DEI regulation is permissible. So I think it's going to take some time for the dust to settle on this. Right now, it's just good for folks to know and understand, and I'll talk about some tips on how to deal with this in a minute. Not surprisingly, there's a number of states' attorney generals that have issued guidance challenging it, saying that, look, DEI is not illegal. It is absolutely, permissible, and that, policies and practices that promote diversity, equity, inclusion, and accessibility are not the same as preferences. So a number of AGs have come out, state AGs have come out challenging that guidance. What we have not seen yet, which is it's going to happen at some point, is so now we have the federal government with this kind of anti-DEI perspective. We have a number of states that also have DEI requirements. And what happens when you're trying to comply with state law, and that might impinge on your requirements with the So what we have is a potential battle between state and fed law where there's overlap and conflict. There is the supremacy clause that would give the federal government, generally give the federal government the right to set that policy. However, there are concepts of states' rights. So we'll have to see how that all plays out. Unfortunately, I think nonprofits, contractors, grant recipients, you guys are kind of stuck in the middle right now. So what we're trying to do is figure out how best to navigate this kind of uncertainty as we move along. Okay, so that's some of the litigation. As I mentioned, there was litigation about the foreign aid. There was litigation about the NIH, the OMB freeze. But let's talk a little bit about what all this means for private industry. So first of all, it is absolutely the president's prerogative to set out policy goals and aspirations for its administration, right? The president's been elected, and so that's kind of the, spoils go to the victor. But the legality of executive orders is limited because an executive order is nothing more than a proclamation by the administration. It has no backing of Congress. Executive orders scope really has to be based upon the law in which they are espousing. So they need some kind of legal underpinning to give them force. So in terms of the DEI executive order, the underpinning is the anti-discrimination law or the Supreme Court precedent, and they cite to the Harvard case. However, the scope of that executive order is apparently broader, right? It's ambiguous, but it seems to push that it's broader. So it's important to recognize that executive orders themselves don't carry the weight of law. They don't even carry the weight of regulation. And so what's important is, yes, there's these executive orders out here, but what are the agencies doing to implement them? Because if you read the executive orders, it really talks about what an agency must do to implement this new policy. And that's why you're seeing a lot of guidance from agencies on how to implement this stuff. Eventually, this should all follow with rulemaking. There should be rulemakings that go through the administrative procedures process where a rule is proposed, there's a notice and comment period, and then a final rule is enacted. We haven't gotten to any of that with the things I've been talking about. So, it remains to be seen how effective all this stuff will ultimately be. The courts are pushing back significantly. I will say that there are probably some flaws to some of the cases based on jurisdictional issues, things like that. For the most part, the courts are holding, but I don't expect, there will be some wins on the administration side. There will be some wins. And so we'll have to see how kind of it all plays out. By the way, before I go any further, I want to give the CLE code out. It is Federal Grant 2025. Again, one word, Federal Grant 2025 for those listening. And I'll give that out again near the end of the presentation. Okay, so executive orders, they set out kind of the policy goals, but they don't have the force of law themselves. And so, we're seeing this court step in, and part of the problem, unfortunately, though, is we're not seeing the administration really adopt the court orders. There's a lot of dickering over what an order means, its application to plaintiffs, its application to defendants, what the terms of the order, are the terms reasonable, are they unreasonable? And then those are getting, litigated and appealed. In fact, the foreign aid one went all the way to the Supreme Court, where a 5-4, the justices came back and said, no, USAID, you need to release this money. But it went all the way up there because the argument was that the order was unduly broad and unnecessary in that regard, but the justices did find, at least in that case, in favor of the plaintiff organization. So what are private industries, particularly those that are receiving federal funding? We need to actively monitor what's happening, okay? Because executive orders are being issued, guidance is coming out from agencies. Some agencies have rescinded guidance, they issue new guidance. Court orders are coming in, it's changing the guidance. So it's really important to monitor so you can quickly adjust to avoid scrutiny and impact on your organization. On the DEI, so that requires a certification, right? So let's talk a little bit about what does the certification require? Well, as I mentioned, some agencies are merely asking contractors to certify to the DEI EO without really saying anything else. By signing here, you are agreeing to all the EOs. Okay, well, that's really vague. I don't know what that means, and how do the court orders play into that? Some of them have limited it to federal dollars, and some have limited it to, made it organization-wide. The main thing that I want to make sure that organizations are aware of, okay, so let me talk a little bit about what certifications mean. So what does a certification mean? Well, first of all, anything that we provide to the government, you provide it under a False Statements Act and a False Claims Act kind of intention, okay? And both of those carry both criminal and civil penalties. Now, what is knowing and what you're submitting can vary under these statutes, but it doesn't have to be actual knowledge. It can be things like reckless disregard or deliberate ignorance of the truth. And why is that important? Well, if you sign a certification without thinking about it twice, that might be reckless, right? You didn't look into whether or not you're complying. Or it might be deliberate ignorance because you don't want to know what you're doing. So knowledge can impact those things. So even though you don't actually know something, if you're signing something without doing some diligence and some reasonable assessment, that can put you in a bad spot. It's also important to note, I talked about whistleblowers. The False Claims Act actually codifies the whistleblower concept, and it allows whistleblowers to actually receive some of the recovery that the government might receive in a False Claims Act settlement or in the judgment. They can receive up to a third. So it's really important to make sure that you're conforming your practice, you're doing some diligence. Talking to counsel helps show that you've done diligence. Keeping good records, those types of things will show, what have you done to try to conform, even though things like the DEI, it's unclear exactly what they're getting at. Are you trying to conform to it? Are you doing a reasonable effort to conform to it? And so those are the types of things that are going to help you kind of avoid False Claims Act. I was talking to a client just yesterday about this and said, look, at the end of the day, none of us know exactly what they're construing as illegal, but if we're doing something, well, that's better than nothing, right? And so at least you can demonstrate that you've taken some efforts to try to understand what the administration is doing and conduct yourselves in compliance with that to the best you can. So what should we be doing? Well, on the DEI stuff, I think it's really important to do a few different things. Number one, those certifications are critical. Understanding if a certification comes in before you sign it is extremely important. While those have been enjoined, I know that these things are still happening. And so making sure that your staff understands if a certification comes in, we need to funnel that to wherever the appropriate person is that's reviewing this and getting counsel on that. Because we need to know how broad or narrow that certification is. Is it something we can agree to or not? We've seen these show up in just random emails. We've seen them show up in RFP and RFQ documents. So they're showing up in all places. So it's really important to make sure that your staff understands the importance of that. And they look different, right? I talked about one looking like, by signing, you're agreeing to complying with all of the president's executive orders. Well, that is a certification. So we need to be mindful of that. The other thing is to make sure that you're getting your arms around your DEI program. If in fact, at some point, DEI is construed to be illegal or whatever, wherever the dust settles on it, we just need to know what we have so we can consider, what we need to do to conform our conduct with the law. So getting your arms around what you have, you don't necessarily have to do anything just yet if you haven't signed a certification. If you've signed a certification, you may have to do something. But if you haven't signed a certification, you don't necessarily have to do something yet, because remember, that law hasn't changed, but you should know what's out there so you can conform your practices, or when the time comes. The other thing to think about is staff communication. So the way I think about it is you probably have staff that are very much in favor of DEI. So you've got one group like that. You've got probably a middle of the road group that's kind of indifferent on those things. And then you might have a group of staff that is in alignment with the president's views on DEI. Now, most organizations have been concerned about the affected group, that first category, that they don't want the workforce that is most impacted by the removal of DEI to become upset and disenfranchised. I get that. But that third category is really important as well. Part of the reason I think that all this is kind of, we're having this big swing to the right is that that group has felt disenfranchised for some period of time. And it's important within your organization as you work on communications, you think about all three groups. And you don't want whistleblowers either. So you want to make sure that everybody understands that the organization is assessing, monitoring, and doing its very best to conform its practices with the change in the potential change in the law. So making sure that you think through your staffing communications is key. And then the last item I'll say is kind of you've got your arms around your DEI program, but you need to understand what your risk tolerance is as it relates to those types of programs. Is it something that you're willing to push back on if there is an inquiry? Because just because you're investigated or there's an inquiry by Department of Justice or the administration, it doesn't mean that you've actually broken the law. And like I said, the law on January 19 is exactly the same as it is today. If you feel very confident about where you were on January 19, you may say, you know what, we're good, we're confident, we feel good, and move it forward, and we'll see where it goes. And if the government has questions about it, we'll address those questions, but we're not changing a thing. I will say that many organizations are concerned about kind of creating a target on their back, right? So many organizations have pulled information from their websites, public-facing things, so they don't become a target. But that's part of that risk tolerance. They're not doing it because they're saying that we must have been violating the law. They're only doing it to lower their risk profile. And so those are things that organizations need to figure out. Do we want to do those things now? Do we want to wait and see? Do we want to rescind things? Do we want to revise or rebrand things? That way, if and when the time comes where there's some clarity here as it relates to certifications, as it relates to what constitutes illegal DEI, having your arms around things, having the internal discussion, and it's a hard discussion about DEI programs, but having all that done, then when the time comes for action, you can take quick, decisive action and get yourself in compliance quickly so you can sign a certification. So I'm going to stop there. We're at about 45 minutes on the dot and turn it over to Janice maybe to throw some questions out. I know there's some in the chat feature. Please feel free to use that or use the Q&A feature. But I hope I made some sense for 45 minutes.
Yeah, so there's a lot of really great questions in the chat. I've kind of selected out a few that I think, are on similar topics so that we can address them. Some of this is kind of backing up a little bit and thinking about, or whether you can explain, what is federal financial assistance, or how do I know if I'm a contractor or a grantor? It's obvious if you've signed something, but for other organizations that may sort of receive federal funds, can you speak a little bit, maybe indirectly, can you speak a little bit about maybe how the EOs might affect them and what they should be thinking about going forward?
Yeah, that's a great question. So the EOs generally speak to contractors and grant recipients, but that OMB memo referred to federal financial assistance. And federal financial assistance is a term that's defined in the Uniform Guidance 2 CFR Part 200. And I can't tell you what it says verbatim, but it does include anyone who has agreements with the government, but it also includes subrecipients and subcontractors. So even if you're not in direct privity with the government, there can be a cascading effect to lower tier parties So I would advise take a look at 2 CFR Part 200, the definition section, and federal financial assistance is specifically defined there.
Another question that's come up is, what do we think about these certifications that contractors or grant recipients are being asked to make with respect to affiliated organizations with the contractor or grant recipient? So perhaps subsidiaries or other kinds of entities that have relationships with the contractor or the grant recipient.
That's a great question. So certifications are typically focused on, well, let me start out. The EOs are focused on contractors and grant recipients. And the way we view that in the legal industry is that is a very particular entity. That is the entity, right, that's in privity of contract or privity of agreement with the government or privity with a higher tier. Certifications that we've seen are the same. They're focused on the actual contractor or grant recipient. There is precedent in the government, in regulation in the FAR and in the uniform guidance, where the government has considered things that go beyond to attach to not just you, the contractor or grant recipient, but all your affiliates. That has not been done here. We do, fortunately, some of these things are not completely unprecedented because during COVID, we had the vaccine mandate that applied to contractors and grant recipients. And the Biden administration tried to push that out pretty broadly and got his hands slapped by the courts for that. And so we do have some precedent that things that were done as it relates to vaccine mandate are very similar to what is trying to be done here. And so I think we'll have some favorable case law in that regard, which is also why I don't think they've maybe pushed it out to affiliates. Certainly it's sometimes considered, but right now everything we've seen, it's not impacting affiliates. But, you know, like I said earlier, we haven't seen any actual regulations and any actual formal language in the CFR. And so I will reserve judgment whether that is a dead issue or it could be an issue on the horizon.
A question about the 90-day pause in the foreign aid executive order that you talked about and a similar pause that was in the executive order on climate. We are seeing the agencies during this period moving to terminate contracts and grants. And you spoke a bit about it may be questionable what authority the government has to terminate contracts and grants. And I'm wondering if you could speak about that a little bit more in terms of the variation. Obviously depends on what the statutory authority says and your contract and so on and so forth. But you know, what is typical, what you're seeing, and what recourse do grantees or contractors have when facing a termination?
Great question. So let me start off with contracts. So contracts is kind of the easier side of the question because contracts generally include what's called a termination for convenience. And that means the government at any point can terminate the contract without cause. In fact, there's case law out there called the Christian Doctrine that provides that even if the government fails to include that provision in a contract, because of the sovereignty of the federal government, it retains that right. So it can always terminate a contract for convenience. The recourse for that, though, is lost profit. So I had expected this contract, you know, and you pulled out on it. Well, I put all this time and effort to get this contract. I'm entitled to something. Sure, you're not entitled to the cost of performing because we're trying to save those costs. But if you had $1 million profit that you had anticipated, you would be entitled to that. So contractors have a very clear path Now, one of the problems with some of the litigation has been that they've gone straight to district court. And I'll note that contractors are also subject to what's called the Contract Disputes Act, which throws them into an administrative process on disputes. So we've seen some of these cases have some jurisdictional issues because contractors are trying to go to district court in some of these, in the foreign aid case and some of these other cases. And really what they need to be doing is filing a claim with the contracting officer, waiting for that to be denied, and then going to the next tribunal, which is either the board or COFTI. Now, I know there's one case out there where they're trying to skip the 60 days required to allow the agency to respond, and we're monitoring that case. Currently it's at COFTI, at the Court of Federal Claims. So that will be important for contractors in filing claims. On the grant side, so grants don't typically have a termination for convenience. Uniform Guidance 2 CFR 200.340 lays out the reasons the government can terminate. And it includes things like non-performance and violation of law and things like that. So causal reasons. And then there's a provision in there that the Biden administration altered about a year ago, that if the government wants to terminate because of a change in policy, it can do that, but that term needs to explicitly or expressly be in the agreement. The Biden administration anticipated some of what was happening here and put that provision in the Uniform Guidance. Not surprisingly, many grant agreements and cooperative agreements don't have a provision that says the government can terminate because of a change in policy reason. So many of the grants that we're seeing terminated are being terminated illegally. There's no basis to terminate. Now folks are pushing back and appealing those, but here's the issue with grants, is that grants are not profit generating vehicles. And so what if the government wanted to terminate and cut off all costs, then what's the grantee left with? And that's kind of the issue is, well, we're not going to get the work back. So, what do we get? Well, there is an argument that maybe the indirect, because organizations built their indirect structure based upon having all these grants, and the removal of those grants cuts their base, and therefore they're losing out on how to pay for indirect. So that's one argument. And the other one is really the impoundment argument that, look, like, you're not permitted under statute to terminate this program. This program is required by Congress, and you can't terminate it. So you need to reinstitute that. So that's another argument that we're seeing. In the grant world, you don't have the same administrative processes necessarily as you have with the Contract Disputes Act that I talked about. Agencies are supposed to have appeals processes, but some of them are well developed, like HHS, and some are very underwhelming. And so that process is not as clear. You do have the opportunity maybe to get to district court under an Administrative Procedures Act case, but often you have to exhaust those administrative remedies first. So you've got to look at what process the agencies do have, even though they're not well articulated. Some of the concerns I have is that they're not well articulated, so I don't know how long the agency gets to sit on my appeal, right? So it goes into a black hole at USAID that has, virtually no one left working, along with thousands of others. When are they going to get to that? And when can I go to district court, because the agency's never going to get to that? So those are all questions, unfortunately, that we're kind of wrangling with. Sorry, long answer to a complicated question.
Yeah, it is very complicated. There are several questions around certification requests that we're seeing coming out of the federal government related to, at the very least, the DEI order, perhaps some others. Just in general, can you speak to sort of the agencies where we're seeing this happen and where we're not yet? Some folks have asked, like, what about like programs that are funded with federal money that come through the states? Like, are we seeing certification requests being flowed down through, those kinds of relationships, or, really sort of where are we seeing it? Where are we not, generally speaking? Can you speak to that?
Yeah, another great question. So primarily we're seeing certifications come directly from the federal agencies. I've seen some flow down from higher tier organizations, pushing them down to sub-tier organizations. I have not seen states pushing those through. I think in large part because, there's an injunction in place. I think, many states disagree with the DEI executive order, so they're just not doing it yet, and they're abiding by the injunctions. But I will note there's also a lot of states that do agree with the DEI. And so there's a host of states that are doing their own kind of DEI, anti-DEI activities, executive orders. We've seen some legislation come out of some states. And so that's something to also be mindful of, is that you might have state requirements. Now, most of those things that are happening at the state level are more internal, where they're trying to scrub DEI from their agencies, but not pushing it out to contractors and grantees. But the short answer to the question is we've not seen a lot of flow through yet. But that also, I think, is probably because we haven't had actual changes in regulation yet. So that's another reason why that hasn't flown through, because there's nothing that says it needs to be slowed down. Now, some of the requirements I've seen from the feds have said to slow them down. And like I said, I've seen some primes pushing these down, but not en masse. So it's still kind of very much of a patchwork situation.
Got it. There's one question here that I think we'll have it be our last question. And it's related to whether there's sort of any risk to tax exempt status in connection with a nonprofit organization's DEI programs, whether that be, by disclosing them on the 990 or otherwise. And I would take that. I mean, to the extent that you do not receive federal funds, you are really in this position of, I think, where this slide is that Diz has here and that he spoke to at the end before opening up for questions, is that the executive orders don't really apply to you at this point. The things that I think we are, looking at very closely in the private sector for nonprofit organizations in particular that are engaged in programs or activities that you might group under the DEI label, or perhaps you are engaging in grants or other kinds of, internships or programs that may involve some element of, preference based on race. For example, we are looking at the potential for private civil litigation under Section 1981 of the Civil Rights Act, which prohibits engaging in contracts, discriminating in contracts on the basis of race. That's something that we're looking at. But on the tax exempt status, no, there isn't anything yet. There is a doctrine called the illegality doctrine, where an organization that is substantially engaged in illegal activities would not be entitled to tax exempt status, but it is very rare. So it's something to watch for. But for now, no, I don't think that there is threat to the tax exempt status. So with that, I think we will conclude our program. Do we have to repeat the CLE code? Are we good?
I'll give it out one more time. Federal grant 2025, and thanks everybody for zooming in and joining me for the past hour.
Thank you, Diz. Thank you, everyone. Take care.